MorningLine, our guest is Tim Takacs. Several callers asking whether or not, Tim, he's our elder care law attorney, you would classify the shade of color of your bow tie to be pink or fuchsia. Very serious question.
I think it's probably fuchsia.
I'm with you. Would you say bow tie is one of your trademarks?
Yes.
Yes.
I would say so.
I just love it. And it's a bright one. It is good to see. You've been wearing bow ties as long as I've known you.
Yeah.
And it's colorful. Well, thank you for coming on, Tim Takacs. We can take some phone calls this morning, 737-7587, if you'd like to join it. Tim, listen, this is something you and I have talked about before, but someone had contacted me about asking you just to go into a little more detail on when and why and how hard it is to decide on getting a power of attorney for an elderly parent. And I've done this for my folks. And that there are different types of power of attorney, both for financial and medical, and if you want to get them both at the same time, all in one document. If you want to walk us through that.
Usually what we do is that rather than do one document, we'll do a separate document. So we'll have a separate healthcare power of attorney. And then we'll have another document for the legal and financial part, the durable general power of attorney. And really the reason that we do a separate healthcare power of attorney, is that typically, a copy of that typically goes to the healthcare provider. Our view on that is that all of our healthcare powers of attorney are all one page. I've seen some that are like 5, 10, 15 pages. Wow. And basically what we want in a healthcare power of attorney is that we want the person to name their healthcare agent and basically say that if I can't make healthcare decisions for myself, this is the person that you want to that I'm authorizing you to make that I'm authorizing to make decisions for me. That doesn't have to be an elaborate document, but if you've ever been I'm saying if you've ever been in a doctor's office, and hopefully most of us have been in a doctor's office, doctors have charts, they have a folder, that has your name on it, and that folder has all this paper in it, and typically what we've seen is that your doctor or your healthcare provider will have the healthcare power of attorney that is, say, pinned, into one side of the like maybe the left side of the folder. Mm-hmm. So we don't want that. We don't want that to be more than one page. We want basically to say, okay, you open that up, it's one page, and you can see here's the patient's name, here's the first agent, here's the second agent. And it doesn't go into detail at all about what the healthcare agent or what the patient wants or doesn't want, because the more detail that you put in there, the more you're explaining, the more you're losing.
Yep. So keep it vague. And just so we're clear then, Tim, when you have that document, and I agree with you, just one page, I think mine's maybe a page or two. When I have that, then that allows me to get access to the medical questions, details, things like this. There's HIPAA laws out there to assist my mom or dad. If they are incapacitated, I can make the call on what they'd like to have done. I can sign off on various different things, whether it's medicine or otherwise, on their behalf.
That's exactly what it is. Exactly what it is. And then, and we have people that come into the office from time to time and say, well, what about a living will? And we don't use those. And I know we've talked about that, in the past, where living wills are basically what happens to you if you have a terminal illness or if you're in a persistent vegetative state is what it's called. What would you want in those situations? Those situations are not, they're not common. Yeah. Where you have a terminal illness and you can't make a decision for yourself, or you're in a persistent vegetative state. But we don't want those documents to be misconstrued as do not treat or do not resuscitate requests. Because remember, you only get one chance at this, and if the provider misinterprets it, all you get, your family, all they get is, oh, well, we're sorry, but we thought this is what we thought this was what your loved one meant.
So what you've talked about then is that as opposed to living wills, your preference would be, gosh forbid, if a parent gets in a persistent vegetative state, you want a power of attorney for their offspring or whoever they give it to, who can then tell and verbalize to the doctors because then the doctors can ask questions, I can answer it and say, well, this is what my mom and dad wanted, as opposed to a living will that potentially could be incorrectly interpreted.
Exactly. Right.
Wow. Yeah, and that's important. A lot of people go with living wills, and maybe sometimes they have no choice, or maybe they just want to be that specific. But, as an attorney, you are someone where if they have the means and the ways to do so, you say, don't do that. Go with power of attorney.
Go with this. Exactly. Exactly. Like you basically, Nick, you hit it exactly on the head is that, if let's say one of your parents, gets into that situation, you and your brother would have a conversation about, okay, what should we do? Get the information from the healthcare providers. What are our options? What's the likelihood that there's going to be a good outcome? All those sorts of things where the two of you can assess that, and then you make that decision based upon the information that you have at that time.
Yeah, I just think, again, that's something I've learned from you, and I think it's brilliant. So that's, I think the way to go. Now, the other side of the coin is the financial power of attorney. Medical, pretty clear. I don't know if you would say one's more important than the other, but the financial one allows me to have access to my parents' bank accounts if I need to transfer funds to assist them. And why would I want this? The only reason I want access to this is because my folks now are to the point where they have trouble managing money. They're slowed down. They're still fairly lucid, but it's just they can't manage their finances. That's where I can help them out. But without power of attorney, I couldn't get access.
Exactly. Yeah. So you have a power of attorney or a durable power of attorney document that gives you that authority to act on their behalf, to make legal and financial decisions, and so on. So basically, what you've got is that they have money in the bank. They've got maybe a financial services account with somebody. Those providers, those financial institutions, they're getting copies of those instruments from you. So that they know that when you call or that you have authority to act on their behalf. That's essentially what it is.
And the important thing,
I've always,
important thing then, Tim, to remember with regard to both of these is you need to act and get it together and set these up while your family members or loved ones are still able to sign off on them, correct? Because with both of mine, my parents had, if you're waiting till they're persistently vegetative, hey, you're not getting a signature. That's going to be a problem. That's where you're looking, I guess, at conservatorship or whatever. But in this case, you want to get these things lined up because your parents or whoever it is, need to sign these documents along with you. Maybe just talk about how that works. And if you would, Tim, just in general, if someone's just seeking this out, how much typically does it cost? And I like asking these because I know people want to know to set up power of attorney.
Yeah. So let's get to the last question first. Let's say, you're looking at, a basic durable power of attorney or a healthcare power of attorney. You're probably looking generally maybe $750 to $1,000 to get those documents in place for a single person.
Okay.
That's really kind of like a starting point. Now, needless to say, our fees typically maybe more than that because we're doing for most of our clients that are coming in, they're really looking for a more comprehensive estate plan. Where they're looking at not only the powers of attorney documents, because they may not have anything. And so we're gonna make sure that that they not only get what they want, but also get what they need. But let's say that they're coming in and they're doing a durable power of attorney and a healthcare power of attorney, and that was all that they were looking for. Then that's kind of typically what I would expect the fees to be on that. But when they're coming in, one of the things that we're going to be talking to them about is that, okay, so you have 3 children and you have, and they're all obviously they're all adults and they're all maybe in good health and they're all reasonably, have some financial acumen or whatever it is, or they would be good powers of attorneys, in fact. We're typically going to say is, okay, who's the person that is available, most likely going to be available, that can do it. So yeah, maybe you have maybe your son is in California, but you're living in Tennessee. Well, your son could do it, but he's really not, maybe he's not accessible when it's needed. Of course, that's needless to say.
Sure.
That's less of a problem now than it used to be. But nonetheless, those are conversations that we're going to have is that who's able to act for you, and when you need something done, can they do it right away? We also want to look at, are you going to have a backup? So you name your son, that's in Nashville, and you name your daughter who lives in Knoxville or someplace like that or whatever. So you always want to have a backup plan. You don't want to have powers of you don't want to have powers of attorney, because we see that a lot of people that are walking into our office that bring powers of attorney with them that they've had other lawyers do. And they'll, the powers of attorney will say, I name my son and or my daughter, as my attorney, in fact. Well, is it your son and your daughter, or your daughter? Does the lawyer could not make up his mind or her mind?
Right.
So we basically, what the point here is that the purpose for this instrument, is not to appease or to respect a child or other family member. The point is to convince an unrelated third party that this person that you're naming has authority to act for you.
Yep. And that's Listen, we'll take a break on that.
That's the thing.
But that's the thing with my parents. My brother and I, and my brother's living close to him, we're both power of attorney. We both have it. We're on the same page.
Right.
We go that way. And keep in mind, power of attorney is not a conservatorship, which we can touch on if we want when we come back from the break. But the person who's giving you power of attorney is not giving up their rights. My dad can still write checks and still get access to his bank account and all this. It's just I'm there if he needs assistance. I have power of attorney to intervene if needed. That's the difference.
Exactly.
They're not giving up control of their assets. They're sharing it, or at least allowing me to assist them if needed. So we'll take a break on that.
Is that you're not giving anything away. You're sharing your authority with somebody else.
Exactly. Listen, we'll take a break on that, come back, and I think Tim has some other cautionary tales on how that can be handled. We'll talk more there. We can touch on conservatorship. I've got some other questions that have come in for you, and we may take a few calls as well, Tim. So stay with us. We'll be back with Tim Takacs, elder care attorney. Your questions about these things that we're all going to have to deal with at some point when we come back. Stay with us.